let's get started. So again, so let's get and so I'm honored to introduce the speakers today. So my left, Mr. Don Karn, so from Davis Polk. So Don is a partner of Davis Polk in a white collar defense and investigation group. So he represents companies and individuals in government enforcement matters, conducting internal investigations and in compliance matters. He previously served for 11 years at the Department of Justice, where he held a number of senior level positions, including Deputy Assistant Attorney General of the Criminal Division, Chief of the Fraud Section, and Chief of the FCPA unit. And next to Dan, so Ms. Rolinda Roy. So she has been with the Department of Justice Criminal Division Fraud Section since 2014, and is currently an acting co-principal deputy chief of the Fraud Section. Ms. Lorinda was previously acting chief of the Fraud Section and the principal assistant deputy chief, an assistant chief, and trial attorney in the Fraud Section and Foreign Corrupt Practice Act, FCPA unit. And on next to her is Ben Morgan. So he's a partner in Freshfield in the internal corporate crime group. So he formerly is a board member and joint head of the bribery and corruption SFO. So and he had a lead role in genesis and implementation of the UK's ability to resolve corporate misconduct through the use of the Deferred Prosecution Agreement, DPA. So being responsible both for the first DPA and also what was at the time the largest DPA involvement joint resolution with UK, US, Brazilian authorities. With them, with you. And next to Ben, so the Brian Bankowski. So he is a partner at Cochran Ellis in Washington, D.C. office. So he is a member of the firm's government regulatory and internal investigation practice group. So he recently returned to the firm after serving for 2 years as a Senate confirmed Assistant Attorney General for the DOJ's Criminal Division, his sixth senior management position at the Justice Department. So now, so you know that, so they're almost all-star members to discuss the DPA. And as an introduction, so I introduced the so-called Monaco memo. So issued on September 15th. So this year. And the contents of our remarks and the memo issued on the same day. So and the release are kindly covered in our remarks. And as described in the remarks, the U.S. approach, so it can be said that U.S. approach to fight against the corporate crimes, so is often very complex. So, and it's really difficult to monitor and detect from the outside. So, is to develop an effective incentive structure, so-called carrot and stick approach to encourage companies to prevent and detect corporate crimes. And discussing their pre-bargains, including the DPAs. So how they use this structure and tool to resolve the case. And related topics such as voluntary disclosure and cooperation from the perspective from incentive structure is very, very helpful for many countries like Japan, so and companies like Japanese companies to develop their governance systems. So not only the governance system of the society, but also a governance system within the company. So having said that, so we dig into the
focusing on the DPA. And first of all,
so we can start discussing the differences between the DPA and the guilty plea. So
And Brian, so I'd like to ask you to cover these two questions. The first is what is the difference between a duty free and a DPA and PA?
Thank you, that's good. And thank you for inviting us all back to the flag in this word back where we were back in 2018.
The difference between a guilty plea and a DPA and an NPA is sort of first principles, but I think folks understand that a guilty plea involves a corporation going to court, admitting certain facts and admitting that it is committed a crime, typically a felony. But the first prosecution is different, so it's different. I think people know, but it still involves going to court. A charge is filed by the government and there is effectively an agreement between the government and the corporation about how what that company will do during pendency of the prosecution and any obligations. The case will be dismissed, the charges are dismissed at a later time. And non-prosecution agreement is effectively that agreement between the company and the government, but without the filing of the charge and some oversight under there that typically involved by the courts. So why is it important for corporations why do corporations prefer deferred prosecution agreements and certain non-prosecution agreements? One is when a company is forced to go in court and admit that it has committed a crime and pleads guilty, there is a statement of facts that's typically associated in every one of those facts the company owns going forward. And oftentimes creates tremendous collateral risk for the company to have to make those admissions and acknowledge that it's a felony. If you're a financial institution, you're going to indicate your ability to manage pension assets going forward. If you're a pharmaceutical company, as we mentioned earlier, there's suspension and environmental risk that have to be managed. And if you're just a garden variety corporation that is less heavily regulated, there's still issues with your creditors, with debt covenants and other things where it can have severe impact on a company's ability to manage its balance sheet. On top of all of that, there's the reputational damage associated with admitting that you were a felon. And going forward, having made that admission, what that might be if you're a very large, particularly multinational company with lots of operations and flying around the world, having admitted once that you were a felon and getting in trouble again, what exactly means for you as a corporation going forward. And so the history of a company, I think when we talked about this, it's going to be very important going forward. And we see things like predictability, and I think that's very important. It's going to be very important for companies that make very difficult decisions about self-supporting, and knowing and having some sense of what this is all going to mean going forward in light of these new rules. I think it's going to be very important, and I think that from a practitioner standpoint, we're very much looking forward to seeing how the department and the criminal division are going to resolve cases under this new regime. The carrot and stick approach, I think what we're starting to see in the area of corporate crime is something akin to what we've seen more broadly in our department over years, which is when new administrations come in, there's very basic documents in the department that defines for prosecutors how they should charge cases, and oftentimes those documents allow prosecutors to take a tremendous amount of discretion. But we sort of have this back and forth between administrations about what the charging policy is going to be. And I worry in context that we're starting to see the same thing. That when administrations change, there's going to be changes back and forth in how the carrots and the sticks are calibrated, and that will have an impact on predictability. So my hope is where we're headed, and where the department's headed, and where we're headed in the United States is towards refining these policies. And that hopefully we can reach a point where we all agree that we hit a calibration point in the carrots and the sticks that everyone can agree on. And we have a system that goes forward where there's not really a lot of people back and forth about what's their carrots and what their sticks are. I think we have a conversation something about the ACMO and information about everyone involved, all information about individuals. I think that's in particular an area where we keep going back and forth like this. that incentive structure, that is capable to change will be part of the chief.
Thank you.
Thank you. So
Here,
So
the
here, so
James
the
and Lorinda.
DOJ, so Lorinda. So could you share so yourself so from prosecutor perspective in this question, so the difference between the DP or DPA and how important so it is from the DOJ perspective or prosecutor perspective.
Yeah, I guess, what I would add to what Brian said is, Brian mentioned that there are factors that we have to consider in determining what resolution is appropriate in each corporate case. And some of those factors, by the time the company discovers the misconduct, they may not be able to control it. Make sure the offense, pervasiveness, being two that come to mind, that maybe just be set. But there are factors that the company can control, right? And those are the ones that understandably, that Monica hit on in her speech, and Lisa mentioned today too, voluntary self-disclosure, cooperation, and mediation, just being three of them. And so those are factors we have to consider when fashioning the appropriate. And again, that is a place where the company does have a lot of control over what it's going to do with respect to each of them, and what it's going to do to try to if it's very focused on trying to avoid guilty. Those are some levers that it can constantly be thinking about going and fighting. So that's what I like to say.
Thank you. So Dan, would you like to add something?
Yeah, no, okay.
Yeah, sorry. But I was about to start with the disclaimer, which is that I start my own, not of the department.
So what I would add is, I think there's a couple points. One, as a logistical matter, just to pile on to what Brian was talking about and agree with everything that he said. A lot of times, not always, but a lot of times, the substance of an NPA, a DPA, and a guilty plea are exactly the same. And so the only difference is the company is actually going into court and pleading guilty. And so accepting it, and Brian's 100% right, that will oftentimes lead to a lot of collateral consequences. But it's also important to keep in mind, as we're talking about the carrots and sticks that Brian and Lorinda, I think, very appropriately flagged, is a company, whether they get an NPA, DPA, or a guilty plea, still are subject to significant cooperation requirements. They're still subject to requirements to disclose any new misconduct during the term of the resolution, which is very significant. If you think about it, if anything goes wrong anywhere within the company during the 3-year term of the agreement, they have an obligation to turn that over to the department, which then could lead to a lot more investigation and potentially another resolution. And according to the DAG's new guidance, which we'll get to, would mean that there is a presumption of a guilty plea because now they're a recidivist. And so all of those obligations oftentimes carry with a company, regardless of whether they get an NPA, DPA, or guilty plea. The other thing I would just pile on to what Brian was saying is I do think that there is some negative consequence to this sort of ping-ponging back and forth every time there's a new administration. And I think one thing that Lisa and Lorinda have done extraordinarily well, and really under Brian's leadership in the criminal division was done exceedingly well, is there really wasn't a lot of changes to try to get away from the prior administration. There was building on to the prior administration. And so under Brian's leadership, for example, there was additional monitor guidance in the monitor memo. There was new guidance for compliance evaluation. There was new guidance for piling on, the anti-piling on policy, and there was new guidance for inability to pay. So I think, and I think Lisa and Lorinda and their teams have done a really good job of building on it. But again, I think there is some danger where you see this desire to really separate departments from prior departments, and the risk that does lead to less transparency, less stability, and as a result, companies sort of scratching their head, thinking, what are we supposed to do here?
I'll say two things. One, I was curious to hear what are referred to as, here's their DPAs and their called procedure for accommodation and cooperation. It sounds so much nicer for the prosecution. From the government's perspective, at least in our talkings, for us, it makes it look lazy because we preferred something. And if you're a company where the prosecution is in the name, so I would make a motion at some point.
The name of our DPAs is the way you describe them, and I think it's a kind of a general way of describing that. I also say that I didn't mean to accuse this administration of the ping pong.
I do think that was me.
I do think what the DAG was trying to accomplish was importing some of the things, good things that have been done, not only in criminal code, but in other divisions around the department. And the antitrust division has had its own voluntary disclosure regime for a long time. And what the DAG is trying to do is take those concepts and apply them department-wide, including the U.S. Attorney's offices and elsewhere in the department where perhaps those concepts have not migrated. And it's hard to do that without laying down what you believe are the part of the fast way to go and follow by everyone in the department. So I do think the department needs to be mindful going forward or problem going back and forth with change calibration, but also understand what the DAG with the health and criminal division was to take things that have been done in the past and try and work the best again across it.
And thanks, Brian. I was going to follow up with that. And I think what Lisa said in her remarks this morning is that we at the criminal division welcome that, right? We've been doing a lot of this stuff for a while. And then with respect to transparency, our policies still remain, right? The corporate enforcement policy is still there. It still guides, I didn't mention it earlier, but it also guides how we resolve our cases. The three levers that I talked about, voluntary self-disclosure, cooperation, and mediation, are key components. The three main factors that considering the corporate enforcement policies, and the third factors are still around, right? So I think there have been refinements. But the core, at least for the criminal division has remained.
Yeah, and I don't mean to suggest either that the department has gone in a bad direction here. I do think, and we're going to get into this as we talk more about voluntary disclosure and cooperation. I think there have been some of the new guidance that has come out has done exactly what Brian said, which is take the great policies out of the criminal division and apply them department-wide, and I think that's a very positive step. And I think some of what has happened is the stick has increased so much that it really casts doubt as to whether it makes sense for a company to voluntarily disclose, and in some cases, whether it makes sense for them to cooperate, because the bar is so high and the consequences are so significant that I think it just gives companies and defense counsel a lot to think about.
Thank you. So now we can confirm that time. So the DOJ will receive the good balance between the stick and carrot. So to incentivize the company to be a good citizen. And I'd like to ask Ben about the UK situation. And then since you import the DPA system in 2014 and there's slightly different legal regime between US and UK. And I'd like to ask what kind of differences. And before that, what's the background? So why import the DPA in UK? And so the main differences of the DPAs between the US and the UK.
I mean, there are a lot of similarities. We have the same sort of system imported into the UK with variations, which is why you asked this question. And the first thing you put up there is material. And the reason for that is that's the sort of gateway to the UK. It's all is actually liability. And it's slightly different in the UK, as I'm sure you know, other than for bribery, corruption, solicitation, tax evasion. Which requires the direct mind of whether the company to effectively be involved in the thing like that, which is completely stark contrast to what you have here. I would say I think that probably makes sense and is always written when you think about industry in these days where Tesco, for example, is a sort of regional grocery store and not sort of special conglomerate stores now. So one understands the origin of that. But fundamentally, it's still that. So other than those two exceptions, you're really talking about the board needing to know what went on. And there is slight nuances to that. So if you're a prosecutor, you would be able to look to expand as much as possible what the director might will choose. And this was really one main which allows you to make work to list other people, other board that would have delegated the same function. That's the one not board to be considered in the same way. But on the other side, the case of Barclays is showing us that simply by being on board, that doesn't automatically need to be delegated to deal with things wrong itself. So there's a bit of flex within that, but it's fundamentally a really narrow position. It is different for bribery corruption and solicitation tax. We have our favourite spend model, which is closer to us on the superior. If somebody does one of those things without the knowledge of the company, but on its behalf, then you're into conversation around DPAs and so forth. And I think the other thing I would say about escapes for this audience's knowledge is that is something that some debates in the UK at the moment. Consultation, now recommendations about actually raising all the compromise that saying events. Because I think about if you have a patient of paper, you will probably say fraud should be one measure. But that's not despite the logic. I see people that's not something that's easily dealt with in the UK. As the answer said, when we were both at the SFO, we made cases with us with the role of the time, and that really sits head on. But my instinct that is the different times. It's much as but I think when that calms down, one knows it does. This is something that might actually start to get traction, which was a long start. What's the difference for us? And I say that because you need to question whether you want one at all. If you do, fundamentally, pretty much the same situation. So DPA is a situation where you've got a liability to resolve it. People have third, higher, this sort of additional behaviour turns down and I'll come back to that a little bit later. So maybe the characteristic dynamic in the UK is slightly different than something that's been recently. The big thing to keep in mind that you do want to comparison in the UK is the role of judges in the constitutional hearings in the UK. And the reason for that is that when we first considered having DPAs, the time in the UK of what it was like for companies to have some side by resolution was pretty big on. And it was a fairly widely held perception that the companies were like there were fireside chats and crazy deals going on. There was some pretty sane vision on the aspects. And DPAs are a bit. So for the DPAs to make it through Parliament and answer that sort of critical content that they face, there had to be some protection for it. And the protection that we have is that once the Parliament, once the SFO, in our case, has reached an agreement, that's not your adversaries quite completely at that stage. But once you shake hands on your 36, you then team up. Because you have to persuade the judge that this is the right outcome. And the judgment is the facts, the terms of the DPA, that's the rule of interest justice. And that's actually a genuinely informal hearing when both parties heard. The judge will examine and the early days, I think that's critical. In the days, Rolls-Royce was very complicated actual cases, a number of different jurisdictions has, and we were sent away, we had to give more information. So it's not in any way a rubber stamp, it's just that the judge must have rubber stamps, and there is a really hard factor, big difference. But 7 years later, I think that on this side of the facts, I would say that I think we've got used to it a bit more. So the process moves through the gears a little more loosely, albeit that same treatment exists, and you need to achieve the same outcome.
That's a stark contrast with the United States, where there's a law on the books, effectively books, several jurisdictions, including here in DC by the DC Circuit, very powerful and well-respected court.
that the role of judges in DPAs is effectively to defer, because the DPA is by its essence purely within the discretion of the executive branch. And the judicial branch really has virtually no role. Judges have tried, and they try to insert themselves on time to time in that process. And the appellate courts have largely put them into place. To me, it's completely because the judges have almost extreme authority to shape the DPA and whatever sounds like. Here, there's almost no way.
They don't quite shape it in the sense that they can't sort of tell you what should be a different voice, but they can say this doesn't do it. I remember in Rolls Royce, the judge's initial reaction, because we've never, that was a £500 million resolution, we've never had anything like it. The judge started the conclusion of, this is what we're finishing, what happened there. Right. Cuts to the so it's, 100 times more serious than the last day. So what they can say is have another day, because I'm
I'm curious about the, I don't mean to hijack the question, but I'm curious about the incentive structure in the United States of taking versus going to the trial. That role in the courts. Because in the United States, it's malpractice. I think in most people's eyes, a publicly traded company, it's taking that right to the trial. It's never happened because of the quality of the contract, even associated with immigration. I don't know if the incentive structure is if you ever roll the sentence in the United States, you would never push it.
It's hard because the story is harder. We've had a lot of proceedings, and I've discussed this, the disclosure process for a prosecution in the UK there's just so many opportunities with being spent. So it's something I never even read as far as the marriage. So the equation for a company is not to rule out prosecution trial. And practically in the UK, if you're telling them not willing to go to trial, willing to go to trial, they're not being willing to say no, then I don't think we're a just that said, it's not a position almost every single I felt that wants to do it, that mark is still allowed despite in the UK actually that I would say a lot less distance between that and DPA in terms of how painful this is. Inevitably, the conversation comes back to one where we're
And Ben, I mean, correct me if I'm wrong, but I think, definitely correct me if I'm wrong, I'm not the expert here, you are, but even a guilty plea in the UK may not carry nearly the same level of obligation that a DPA. And so unlike in the US, where if you plead guilty, you have the same obligations. In the UK, there really is a question of, is it better for me to just plead guilty, get it over with, versus taking on all the obligations of a DPA? But
I'm glad you're at this. That's one of the things I really wanted to sort of communicate today. I think it's a really interesting moment now in the UK around these two things. Non-prosecution, brilliant, and trial, interesting. It's not the best one. But actually, the DPA does have to sit and have the consequences of lenders, maybe the bonds, that sort of thing. But in the end, what the judge can do is pay a fine, and that's the end. There is a discussion about trying to build in additional terms for the fines and those. DPA, it still has it's not the minimum, but it has all of the commitments, exposure, the media, and one of the touch on it is great. We had it in the last couple of years, which it's the same we lost the DOJ in it. And it's the one around self-reporting any misconduct that you discover during the life of the DPA. Which I understand if it's misconduct that happens in the life of the DPA, that's that isn't unreasonable. But if it's things that took place prior to it, but you only learn that. For me, that significantly violates an ethical position that you have the right to fight, so don't have to deal with that. And the example we've discussed before is if I advise the board that they've got a £50 million problem, and the DPA is the right solution for that, and they take this, and they don't, they therefore have this additional tools to then advocate it. if during your life, the DPA, it's got a billion pounds of it, they didn't know about it's a completely different kettle of fish. And I think those schools exist when they're avoidable in negotiating the terms of their completely change the risk nature through decision making. And it's something that I think SSAs reflects on when we talk about the carrot. It really is a carrot in the UK, and it's an particularly like carrots. It's not a very attractive option. So they need to turn the carrot into a cake and make it something they really want. It is going to us tip the balance better way than you see the guys in Ghana.
So who determined in a guilty plea without the requirement of disclosure or obligation that exists in the US system for guilty plea non-prosecution? Can that be ordered in the guilty plea? Make that as a judge or?
I understand the but I've never seen it happen. And I was supposed to register on the DPAs. I was able to resist that we're not there. We're not, you know, the incentive to be attracted to these things. And that gets it was borderline with an opportunity to make that case. And the guilty thing just too unattractive. And so we bring guilty plea and take paying. We want the DPA and paying as the kind of sort, I suppose, to it. But that's no one really to decide in the sense of 100% negotiations on both sides.
For guilty as well, the terms are going to be.
Yeah.
Why not just require those things?
Because it's the term generally just around charges rules, what we collect the calculation of the fine is going to be. And usually what we have is to give a charge of 10 things that should be if it will like it's commercially and from a justice perspective, exactly you can narrow that, and that's the advantage of the process. But even that process is it's generally it's not a challenge to anyone who wants to listen entails. It wants to be doing that, but it needs to be an attractive cost if we're doing it in the first place.
So from Japanese lawyers' perspectives, I'm just wondering. So there's some slightly different regime in the UK and the US, and since you have unique experience both working as a prosecutor and a defense lawyer, and these differences in the global investigation can affect the strategy. So for example, from the investigation perspective, how do you in the joint investigation, how do you deal with the differences between the US and the UK? If that differences can affect the investigation, the joint investigation. So in the US, SFO and DOJ.
Before I like to answer that, I'll just say that we don't conduct joint investigations. It's just a word, but it's actually quite important to us because there are a lot of consequences that flow from that. So whenever the department is investigating alongside the SFO or Japanese authority, we always make sure we are conducting separate parallel investigations. So it might be joint from the company side, or they're looking at it as one, but from our perspective, it's always separate.
And I'll let Ben correct me and Brian correct me, but I think that is a very big challenge for a company, and it becomes even more challenging where you're talking about multiple jurisdictions that don't have the type of relationship that I believe that the SFO and the DOJ currently have, or the relationship that DOJ and a lot of other authorities have. You could see, for example, the situation where the UK, which the SFO may say, we don't want you to conduct any interviews of anyone. We want you to stand down and not interview any employee until we're done interviewing all those employees. And we want to interview them quickly and before we look at any documents. And the DOJ may say, no, we don't want you to make those employees available now. We want you to do whatever investigation you think is appropriate because we want to review all the documents first. And you could see how if the authorities aren't getting along and aren't talking to each other, that puts the company between a rock and a hard place if they're trying to cooperate with both authorities, because you can't cooperate with both. In an ideal world, Ben, when Ben was when he was at the SFO, or currently the folks at the SFO will pick up the phone and call Lorinda, Lisa, or their teams, and just hash out and say, okay, what makes sense here? We're willing to stand down on our request, or you should stand down on your request. But a lot of times the company is really facing, I think, a pretty tough dilemma, which again, and I know we're going to talk about voluntary disclosures. There are a lot of sticks that are already built into the system for voluntarily disclosing. Putting aside the incentives that DOJ creates, anytime you voluntarily disclose, you are these days necessarily going to be dealing with multiple authorities. You're going to be dealing with civil class action lawsuits. You're going to be dealing with any number of collateral consequences that come along with it. And so that's, I think, why it is all the more important why the carrot cake, which, by the way, I like that, I'm going to steal that, is much bigger and sweeter than the stick.
Yeah, and to add to that, I think Dan's point, if they're truly competing requests, or truly conflicting, not just competing, but conflicting, because they're often competing requests all the time. They're truly conflicting requests. The Department of Division of Fraud Section specifically spent a lot of time building relationships with our counterparts in other countries. I've been working on that for a very, very long time while Dan was in the Department of Law. Dan was SFO, Brian was head of the criminal division. And so we're in a place where they're truly conflicting requests. So companies come to us and say, I can't do both. So, and then absolutely right, we would pick up the phone, we would try to understand what is the goal of the request. What is the SFO's purpose in making in asking for a specific stand down or deconfliction or whatever it is, and what is our purpose, and is there a way to accomplish both of them? And I find that most of the time we work through it. Go back to each company, go back to find our requests, refine our requests like differently to get at the heart of what we're looking for. Sometimes ask for something more how it impacts the other jurisdiction.
Yeah, that is the institutions that are utterly, and to be honest, now, the defense side, the only practical thing I've been able to think of how this is fundamentally is up to you. But there are some things that I have an example at the moment, the privilege and there's a document that's being requested, which is one after the other. And one thing we haven't had to do is have an adult conversation with the agencies about the timing of the disclosure of documents, such that we don't leave to the US until you guys have made what you want to do. With the situation where we don't have that document, because that's the correct legal position. But the SFO could have it. Once they have it, it's arguably waived, and it certainly could be shared. And so what I'm just trying to say to them is I'm not providing that document from us. But can you just understand our position on human level that we want to be treated fairly in both jurisdictions, and the chronology of this is the way we're and that has the only sort of thing I've felt moving to influence from the defense side since legal. And I would recommend that and we can get reasonable people and have this conversation.
Okay, thank you.
Okay, thank you. So we already touched a little bit about the voluntary disclosure. So let's move on to the important part of this incentive structure. So voluntary disclosure is always very, very difficult decision. So for the company and so another monopoly memo. So I think there's some stratification and development to reduce the uncertainty. So and create some. So carrot and so make it clear. So And I'd like to ask Loreen, so first, from the investigator perspective, how important it is to encourage voluntary disclosure the company, so from DOJ and enforcement policy. So I think for years, so I think the DOJ has strongly, so encouraged companies to make a voluntary disclosure. And, so there's so FCPA, so enforcement policy, pilot program, and I think this effort is to so make the carrot clearer and bigger for the company. So, and I'd like to ask, so how important is effort?
Yeah, you're absolutely right. The department has been focused on encouraging voluntary disclosure for a long time. The fill factors, which apply department-wide, requires prosecutors to consider voluntary self-disclosure when fashioning the appropriate remedy for corporate case. As you mentioned, what started as the FCPA pilot program, 2017, was it? 16, 17, started as the FCPA pilot program. Now the corporate enforcement policy that applies across the criminal division has as its one of its main goals is to encourage voluntary self-disclosure. And the reason I said it today, if we become voluntary self-disclosure, fully cooperate, fully remediate, the presumption is the declination with appropriate disgorgement, forfeiture, whatever, this crime can pay. So appropriate disgorgement, but a declaration, absent certain aggravating factors. But the voluntary self-disclosure is on-off switch, right? That is the key to get into the CEP, the corporate enforcement policy world. If you fully cooperate and remediate but don't voluntarily self-disclose, you're not eligible. So we have tried to set up not just carrots, but carrot cake, which is my favorite kind of cake, to encourage people to come in, and that is important to the Department of Public Cases. One of them is what Lisa mentioned today. Voluntary self-disclosure. Our ultimate goal is to prevent corporate crime. Right? Our ultimate goal is to encourage, using Gagano's words, responsible corporate behavior. That is what we're trying to get at. And one of the symbols, or not symbols, but demonstrations of the company has a good compliance program, has good policies, and is focused on preventing corporate crime. It is their ability to encourage people to come forward, their ability to detect this conduct, and when they do, to come and tell us about it, right? That is something we consider. So we are encouraging this to help companies themselves self-police, figure out a way to detect their own crime within their own organizations, to take appropriate steps when that happens. So we've been working towards creating and finding the right calibration to encourage. But again, we're not sitting around waiting for our phones to ring. We're not sitting around waiting for people to come in voluntary self-disclosure. We are always thinking about, always using, developing initiatives, developing ways to go out and detect the crime ourselves. We're focusing on data, our data initiatives, data analytics. We are looking, like I said, we spend a lot of time building relationships with our own accountants. That allows us to have open line of communication, data that crimes to call us and tell us about that. We're receiving information from whistleblowers. So we are working to join with the department, other parts of the department who may also learn about, maybe a money launderer who's laundering money for a drug cartel and for, corrupt government officials. Right. So we are using every single avenue we have to continually try to detect this conduct, because that also plays into the voluntary self-disclosure decision. Right. It really ultimately comes down, I think, in part to what is the risk the government's going to find out on their own. And we are trying to work both the stick and the carrot side, which is giving incentives to encourage companies to come in, but also doing our own work on the detection, investigation, prosecution side. That is another encouragement that if you don't come in, we're doing everything in our power.
Great. So I think
I understand. So what the DOJ intend to encourage voluntary disclosure, but so as a defense counsel, so I'm always struggling to make a decision or to make an advice to our client. So the risk and the merit analysis so this what timing we should do so whether we should do the voluntary disclosure. It's very difficult so question, and I'd like to ask Sir Brian. So and you agree with that difficulty, and so please explain how difficult it is.
It's one of the most difficult decisions for the company, whether it's the first time the company's ever experienced something like this, or the most critical part, heavily regulated, that multiple interactions with its regulators over the course of its history. It's a discussion about risk. Both the magnitude and the probability the department's going to find out. It's a great big world out there. Some things that happen in this great big world are a lot harder for the Justice Department to find than other conduct, and depending on where it's located and the magnitude of it and the like. I want to believe that the calibration is heading in the right place to convince companies that voluntary disclosure is the right thing. Because I think it's the right thing generally for society, for corporations to get ahead of their misconduct. Disclose, cooperate, remediate. That's what responsible companies should do. So oftentimes in discussions at defense counsel about do we disclose, you start to feel a little bit like, well, without moralizing, don't you want to resolve this and get whatever risk there is behind you? But those discussions don't occur that way. And so it will remain, I think, one of the hardest decisions for companies to make. The corporate enforcement program, we hold this example out and look at it like this, but cognizant is a classic case where you had a corporation whose CEO, general counsel, high-level executives in on very significant bribery, public corruption activity around the world, and the company came in voluntarily disclosed. And it was ugly for the company, and they got a complete declaration from the department. And so I want to believe that will move in the possible going forward. But also think about the sort of recidivism discussion too, and what that's going to mean. It's really easy operating in the DPA to tell a company you got to take that in. You have to, because you don't, they're going to run around and so. But when you're in year 4, right, the DPA is expired, and you find misconduct that it looks a little bit, and maybe not entirely like the misconduct that was the subject of the DPA, and it's in a different part of the business, in a different part of the world. What do you tell a company to do in those circumstances, right? And we are going to have a discussion about probability the government's going to find it, and those are anywhere there's a really difficult discussions to have.
But I think that's where. I was gonna say, but I think that's where some of the carrots that we're trying to put out there, especially in the case of something as you mentioned, it's supposed to give them some additional encouragement to come in that situation, because I think as that Monica says, and Police said the following day, looking at how those two interact. They're coming, the decision of whether or not to come in could be the line, could be what tips. If there is a resolution ultimately down the road as to whether it's going to be.
Completely agree. And as I said, I want to believe, right? But I think there's going to have to be some history in these policies, because when you advise companies in this situation, showing them what the dad said or what the city said or what the said is helpful. But if you're a general counsel, typically that's
responsive, well, show me where they put that in practice.
So what you're telling me
What you're telling me is
is more than just words on a page, in a policy, in a speech, but where it's actually put it in practice. And the only way that's gonna happen is time, right? Lisa mentioned her resolutions that are coming in, whatever those are, I hope that they provide greater predictability for companies in this situation. Because as I said, I think that responsible companies self-disclose, but they're, they're gonna have to see that they're going to get the care or at least care, and not, not selling them a little share. So, I want to believe, I guess. That's what
And look, I think, I truly believe that the criminal division and the fraud section has done everything they can to try to incentivize this type of disclosure. Saying that they will have a presumption of a declination, Brian's absolutely right. Cases like Cognizant and Gural and ICBL, where you have high-level employees at the company who engage in misconduct and end up getting charged, and the company getting a declination, is about as clear a statement as the fraud section can make. I think the problem is what then happens to the company after they get the declination, and frankly, before they get the declination. There's still a years-long investigation. There's still an SEC resolution or an SFO resolution or a court resolution. There are shareholder suits. The individuals who are prosecuted by the department turn around and sue the company. And so there's all of those consequences. And so on top of that, and this is where, again, I think as well-intentioned and well-meaning as the new guidance is, saying that the cooperation requirements are now heightened. And the second, and this is one of the points that the Deputy Attorney General made in her speech, if a company during an investigation comes across a hot document, something that's really relevant to the department, their first reaction should be to call the department. Well, that's not really practical. Companies need to evaluate the evidence. They need to understand what it is. And frankly, I think the department would want them to understand what it is. And I think that a lot of prosecutors, including in the fraud section and in the criminal division, would understand that and not penalize a company for waiting a few weeks and trying to understand the evidence before they turn it over. But I think the DAG speech, to Brian's point, we have to see how it plays out in practice, because there may be prosecutors around the department who take that literally and say, you know what, you're not going to get cooperation credit. And as a result, you're not going to get voluntary disclosure credit. Because if you don't fully cooperate and fully remediate, you don't get the full carrot or the full benefits of the voluntary disclosure program. So, this notion of heightened cooperation requirements, what counts as a voluntary disclosure to begin with, and then the notion that if you walk it in the door, even if you haven't had prior misconduct, now what you're doing is you're labeling yourself a recidivist. You are now saying, okay, here's misconduct number one. Next time we make a mistake, you can now make us plead guilty. And so I think all of those points, although well-intentioned and attempting to be transparent, I think does add additional ambiguity around the decision to disclose.
One very close to they kind of touched on this, maybe during. I believe the critical, and I believe in the leadership there. They practice, many years across administrations, across the
but these rules now, attorneys' offices, and there are a lot of attorneys' offices that never really operated under the regime like this. So the uncertainty associated in dealing with your attorney's offices, I think, is something that the department's going to have to also do to provide a measure of predictability for companies. Because if you're going to walk something in, it's one thing if it's an SCPA case, if you know it down. You want to walk in some other corporate crime that would largely be looked at. You're going to typically where are you going to go with that?
What if it's an environmental?
Still coming.
You guys don't want to hear it. Always the process. No, that was always my answer. But seriously, I think you need to think around how that's your plan.
But there's a lot pretty clearly there.
So I think that's really point. So it is right. So it looks like the the second paragraph, so if a cooperating company discovers hot documents, or evidence, its first reaction should be to notify the prosecutors. So in this language, so it seems very strong request, so from the DOJ, but so we should also understand the before the first paragraph. So the core message from the DOJ is gamemanship with disclosure and production will not be tolerated. So I think this is very important sentence to understand the next paragraph. So it looks like so once we find a very hot document, so we need to call to the prosecutor. So we have somewhat very interesting documents for you. But in order to identify it is hot documents, so I think sometimes we need to have an interview, or we need to compare with other documents. So in order to understand that evidence, so whether it is hot or not, very important. So I also should believe the Department of Justice, because so in order to understand what it is, so I think we should take some steps, and that could be so possible and acceptable from the DOJ. So that attitude, so I'd like to ask you, so is it okay? So as a defense counsel, so once we find a hot document, but so is it really hot documents? Because so once I called you, for example, it looks like very hot document, but in the future it is not. So so in that aspect, so we can break the relationship, the trust relations between the DOJ. So I do not take such a risk, and so it's very dilemma situation. So defense counsel. So what do you think about that?
Yeah, so I think one of the things that the department has been stressing for a long time, and it's been at the forefront, I think, for all us criminal prosecutors, is individual accountability. That time when this matters. If let's say Dan is doing an internal investigation and comes across a document, maybe US-based CEO that says, I authorize these bribes to this government official in country X. Please pay it through these following channels and make sure you layer it, through 5 different companies so that they will never find out that this is a bribe. I hope Dan's first reaction to the call.
That's not the hard thing.
Some people say not really, but sometimes, and we'll get to this, text messages and WhatsApps, but I think the DAG's position, and I think it's one we all share, is that it should be your first reaction, right? You see a document and you're thinking, okay, this looks really hot. This could be a key piece of evidence that if you tie it together with other documents could help you prove that X person was involved in a crime. So I think what the department expects then is, and we're fortunate that most of the people who are on the defense side doing this were prosecutors themselves before, and so they know typically what would hurt our investigation or what potentially help our investigation, but it may be that, and I think the reason this is there, that it may be that we want the first stab at talking to this. Right? It could be that if you find a document that needs a little bit of context to determine how hot it is, we want to know that, because we want to know whether, again, we have ability to take covert steps. We might have additional evidence that is relevant to that piece of information, that piece of evidence that the company has. And so go out and get false exculpatories, or get some, slightly conflicting information that once we eventually have a document 6 weeks later, and we add up whatever other pieces of evidence we have and go to that person, maybe they end up committed of misconduct, and then we have all these prior statements that are potentially problematic. So I think the idea behind this is our focus on any individual accountability, our focus on getting evidence as quickly as we can, so that we can maybe able to allow us to obtain additional evidence through leads we have but companies don't have, and further investigations that we have, because our goal is always to hold the individuals responsible as efficiently and as timely as possible.
But so just to respond to the hypothetical, because even though that is a clear example of something that would be hot, I don't think as a practical matter or an ethical matter that the first reaction should be to call.
So,
yeah, exactly. Right.
Sure. Counsel, I would expect that document to be produced almost immediately.
But I guess my point is there is a big delta between gamesmanship and turning it over immediately. And so if I have a large client and I call, the deputy general counsel to let him know, he says, okay, let's get the general counsel on the phone. And then, a day goes by, or we need to figure out how we're going to deal with this. We have a sitting CEO right there who's involved in the investigation. We need to figure out how we're going to handle this. And we can't just call the DOJ, and the DOJ that night shows up at the CEO's doorstep, and we haven't even figured out internally how we're going to manage the situation. So my only point is, I think, and I hope, and I do, as Brian said, I believe in the criminal division, and I believe that the criminal division would understand all these points. If we came in and we said, look, we turned this document over to you within a week of when we found it, which still allow you to take whatever steps. It's not as though the statute of limitations is run. It's not as though the CEO has fled the country. As long as we're monitoring and making sure that your investigation is not disadvantaged, that we as fiduciaries to our client and the company as fiduciaries to their shareholders are taking necessary steps that they have to take, but then cooperating as quickly as they can, that's not going to be held against the company. And my concern is the way that it's phrased, a prosecutor could hold it against the company for doing something like that.
Yeah, I would say this. If the department's made it clear that you want more information about more people more quickly. Right? No doubt. And the harder cases are the ones you see all the time. It's not the you described. It's something a lot less uncertain. And as outside counsel and inside counsel, the dance point about fiduciary responsibility, I would hope that, and I realize that some of this is about lawyers and who you trust and who you don't, and the comments about gamesmanship on disclosure are well taken. But outside counsel have an obligation, inside counsel have an obligation to run down those facts and then come to you as opposed to the puzzle, as opposed to one puzzle. And as outside counsel is running the department for the document, that may or may not have evidence of crime. Maybe evidence of nothing. We're going to be a perfectly good explanation for what's in there. If you do that more quickly, more people, you run the risk of creating a company that ultimately will be really good. And I think it's a better policy for counsel to bring as much of the good work as possible rather than limiting to instances. Because I think that's actually what the department has wanted in the past, this sort of context and more complete picture rather than one piece at a time. And so it's hard to navigate that with companies because you don't want to make a mistake. Or senior executive on the access of the department, and then find out 6 months later that actually there was nothing to this, right? It creates problem for you as an outside lawyer and credibility issues with your client going forward, but it also creates problems within the company, right? Because now you have essentially identified someone early who then later on is exonerated, and that person's view is going to be where do I go inside the company to get credibility back. So I think you have to be very careful about how you do this. And I think the problem is the issues with the and that standard are well documented as having not been particularly effective in the past. And it cuts against more information what people are typically in you have those people, right? And one's maybe like get the process it. And I had experiences under the previous, regime, under the prosecutors, not the criminal, give me a list, and the list is all go through things, you my volumes. It's like, okay, we'll see you in here. And then the department wants to move more cases more quickly. That's completely makes it beneficial to that goal.
But it's always a risk analysis, right? It's really, I think, at the end of the day, what Dan, Brian, Ben have to do representing the company, because take that document, you said, the CEO is not going to flee, but if you wait a week and in that interim, the CEO flees, right? I may not be as reasonable or sympathetic, or my response may be, I get that you had to go tell your board and deal with all of that, but now a criminal is gone, and that's a problem. If you wait a week, let's say the email was sent from the CEO's personal address, and now all those emails, that account has been deleted. That's a problem. So it is just a risk analysis, right? The longer you wait to provide that information, if it prevents the government from taking steps that it otherwise could have taken to either secure evidence, to secure an individual that we believe is engaged in criminal conduct, that's just going to be a problem.
That makes sense.
Totally.
Yeah. And that one thing, so yeah,
It's interesting listening to this, because it's a debate with only clients. It's a sufficient threat and a sufficient and a clearly articulated price. It's possible that the departments make a demand like this. And in the UK, we have similar demands, similar language. The sort of one iteration or two of the US policy behind really guidance for this sort of things. But as I've already said, the threat is different, and I would say probably less in the UK. And I was really struck by this remarks this morning about just quite how clearly articulated the proposition is here. But if you do this, this is what flows from it, and you can have a great degree of confidence, I think, that will be the case. And in the UK, it's not possible, or certainly haven't gone that far yet, to give that certainty. So the demands are quite odd, because they're there, and the first thing they say is, doing all of the things that follow can give you no reasonable expectation that your case will be dealt with in a particular way. So, that's a hard conversation to have with your client, that you should then go and, come forth with something really incriminating so you might otherwise have done. I think I actually do understand the reasons for that, because at the moment, the way that the prosecutorial decision needs to be made, you can't really preempt that and better it. And the truth is, you can over time learn to trust and have some experience of how someone will react. But there is a nuance between the two systems, and I'm interested in following this, because I think the next iteration down, that's probably where we'll be as well. So I'm taking notes.
Yeah, very interesting and a very good point. And so one thing, so I have two hats, so academic and as practitioner, and from academic perspective, so I worry about that. So if the cooperation is difficult to achieve, so if the hurdle of to meet and to address the expectation from the DOJ is pretty high. So if it is very difficult for the company to achieve to meet your expectation, so that can reduce the incentive to make a voluntary disclosure. Because once voluntary disclose the case, and in order to get the benefit from the voluntary disclosure, we need to cooperate, fully cooperate with the investigation. But if the cooperation is very difficult, so we decide not to make a voluntary disclosure. So I think I worried about that kind of mechanism. If the DOJ sets a very, very high hurdle, in their cooperation, that could reduce the opportunity for both of the company and DOJ to resolve the good case, the case in an appropriate way. So that is what I worry about. So as an academic.
Yeah, no, that's fair. I mean, I think, or again, going back to it, in the criminal division and my entire time practicing in the fraud section, the expectations have been the same, right? Which is that if a company discovers particularly relevant or hot documents or evidence, and the CPs lay this out. We expect timely, prompt disclosure. Now, the question is always going to be what is prompt and what is timely.
Yeah.
And again, sort of some of that will, because, you know, before this, people always ask, voluntary self-disclosure has to be timely and prompt. What does that mean? Can we do an internal investigation first? Can we do this? And the question is what I told Dan, it's a risk analysis, right? You could learn about it, do an investigation, take your time, but we could then learn about it before you get to this. It's just and then it's not time. Or you can learn about it, do an investigation. Is it a year? Is it 2 years? And come back to us in 2 years? Is that timely? So so for us, the expectation has always been, if there's evidence to discover that is highly relevant, we expect to know about it as soon as possible in a timely and prompt way. Now, to Dan's question of, you know, whether a prosecutor somewhere would use the first reaction as a way to penalize a company, I wouldn't do that. And I have full faith that the criminal division, I think, has been extremely reasonable and fair in the way we investigate, prosecute these cases, negotiate with companies. That I don't
So
have a concern about that for us.
thank you. So the last point, so we'd like to touch, so is our evaluation of compliance program. And so under the Monaco memo, so it looks like two new guidance. So one is a compensation system.
Compensation system and federal. It's a tiny problem. It's gotta be answered.
Yes, I think we've run out of time. I don't have the answers. Look, I'll cover that very quickly. You know, for the compensation systems, Lisa mentioned it today. Kenneth Foley has mentioned that we are going to be considering this issue. We're going to be talking to experts. We're going to talk to our regulator partners. We're going to talk to our agency partners while we consider whether and what additional guidance should be forthcoming from the criminal division on this topic. On ephemeral messaging, if someone has the answer, I'd love to get together with you after this panel.
Yeah.
We'll talk. You have it all? You have the answers? No, it is an issue that has been, has been coming up for a very long time. We see it in our cases a lot. We see increasing amount of key evidence on these sort of these communication systems. And the question is always going to be, like I said from the very beginning, we are interested in obtaining the evidence of crimes so that we can prosecute the individuals who are involved. And companies, I think, have been struggling trying to figure out how to best, to the extent they're not banning these applications. Again, the department does not expect or does not require the guidance. It's not, because currently the CP policy says that to get credit for full remediation, you do not have to ban the use of these systems. So that is, our guidance is clear on that. But to the extent the company is going to allow people to use the system, we're going to have a lot of questions about, what is the company doing to preserve, collect, and disclose that information when necessary. It is, it goes to the company's document retention policy.
Right.
It is a document of the company. I believe it's a truism that the company will want to know and have access and visibility into all communications relating to company business. That should be, I expect, what all companies want. And from our perspective, to the extent there are crimes occurring relating to company business on those applications, our question is always going to be, why does the company not have access to it? And why do they not have the ability to produce this?
Dan, would you like to make some comments?
No, I mean,
One or 2 minutes.
Yeah,
Do you have the answer? You said?
I do have the answer, but you can talk to me afterwards. I'll go through that. But I'd be curious to hear Ben's view, because I think in the EU in particular, this is extraordinarily different, and in certain parts of Asia as well. And so it's if you have work issued devices and an employee is using their personal device, I think it's kind of game over. Like there's very little that the company can do about it. And so you can set up your policies, you can enforce them if you find someone who's violating them. But I think that's the most you can do. If you have the resources, you can have an enterprise-wide messaging app, so you can have WhatsApp across the enterprise. But if you're an employee, are you going to use the enterprise WhatsApp to commit the crime, or are you going to go to your personal device and use WhatsApp on your personal device? And then what's the company supposed to do? So again, I think this is an incredibly difficult issue, and I give the department credit for trying to take it on and to provide guidance. And very much looking forward to the guidance that comes out from the criminal division.
Supposed to determine whether additional guidance.
Oh, sorry. Okay, so if additional guidance comes out, but I just think that this is something that a lot of companies are going to have to grapple with, and I've spoken with clients who have taken varying approaches, and I don't think that there is a right answer, as long as there are policies that are geared at trying to retain whatever messages the company can, and then enforcing those policies, and that's the best you can do.
Yeah, I mean, that's got to be right. You know, for me, it's the same as almost any other misconduct. The company can only do everything they can do. So we've got to work out what that is. But then we have our adequate procedures defense in the UK, which is someone has made their mind up that that's what they're going to do, and they're going to do it. And the only corporate advice I can think to give is you must have done everything you can to stop it if you have. And one hopes that the second case we had a conversation then about defense despite the fact that this thing has happened. But I think the slightly question is the answer, isn't it? Because what is all that the company doing? That's the space.
Those are the sections will be at.
Yeah, I understand.
Okay, so I think almost it's time, and I think it's time to invite some questions from the audience. So if you have any questions, so we can handle one or two questions before lunch. So I think I understand everyone is hungry. So please, yeah, if you have any questions. So okay. Oh yes, please.
Yeah, smile. He knows I will feel it. So this is a fabulous town, and I really think what to loud. So hi, I'm wrong. This is a fabulous panel. I really think you all analyze the issues in such an interesting way. I'm, of course, as some people know, obsessed with inducing voluntary disclosure, and you really highlighted the carrot and stick side so nicely. And then things you pointed out is that it's actually not clear if the shape is so great. Because, and there's a concern about the stick, which is you're unlikely to get caught. The consultant has a very nice empirical study of internal reporting systems, and companies are collecting hundreds of percent of the year, none of which are detected by the government. Your data analytics may fix this, but that's a big issue. On the cake side, I wanted to triangulate between what you were saying and the speech earlier, which is one issue is, well, what does the company get? If it self-reports, fully cooperates, and discourages and remediates, that it doesn't get, if it waits, cooperates with information you guys really need. So you're going to want to give credit to induce that, but doesn't self-report. Under the policy that Dan was talking about, which is the fraud section's de facto approach, but not an official written policy, you were suggesting you might get a declaration. Whereas otherwise you're in a DPA, which is much less fun. Because you're supposed to admit the facts in the time. But under the official policy that's in writing, even now, if you've got senior executives in the big part, that's still an aggravating factor. So you're not guaranteed a declination. And so one question is the criminal division thinking of moving the official policy on defamation? More courts would then seem to be suggesting the fraud section is doing de facto, which is if you're cooperating and helping us get senior executives, you still get a defamation. And then there's a big error.
So thank you for that. Well, I guess my response is always of the fraud section and the criminal division. We're always considering our policies. We're always trying to find the right calibration. We're always considering whether policies need to be refined. But even under the, I guess I wouldn't really consider it as a written versus a de facto policy. I think we all just follow the written policy. But the written policy has a certain amount of discretion in it, right? So the written policy is still presumption against, if you have the three, with absent the aggravating factors. But I think Cognizant is an example where one of the aggravating factors pervasiveness, which includes involvement of senior level executives. And under the written policy, despite that, Cognizant still got the CEP declinations. My point is that it's not under the written policy, there is still a there is, the Cognizant example of a company coming in, voluntary self-disclosure, cooperating, mediating, and getting a declination despite the involvement of senior level company executives.
Yeah, and the only point I would add to that is, from my perspective as a practitioner, if I were advising a company, if all I had to deal with was the department and that specific question, even if there was a senior executive involved, I would probably more often than not recommend disclosure. I think the problem is, and I should say the criminal division fraud section, the problem is these days, what is considered cooperation? Can you meet those requirements from the department standpoint? And more broadly, is the SEC involved? Is a foreign authority involved? Are there going to be class action lawsuits? And how long is the investigation going to be? So I think those are even more problematic than the one issue that you flagged, although I do agree that that is an issue.
Okay, so I think so. I wanted to continue, but so I think it's time. So yeah, again, thank you very much. So I think it's very, very so informative discussion we had. So thank you so much.